welcome to Kitchen Talk, and I'm your host, Lee Ann Moore. Real estate, I've been a real estate broker in California for 24 years. I am also a realtor in Las Vegas, Nevada. And I have found that many times I have acquired listings that find out that the person that passed away did not have a living trust. And the family has to go through a probate process. The homeowners, did not want this to be a stressful thing for the family. So I'm always wanting to talk about having a living trust, protecting your assets. My great friend on the show, Attorney Hauron Nabhan. His office is located in Pasadena, California. And he's going to come on the show today, and he's going to talk about how to avoid probate and the importance of having a living trust. So if you're on YouTube, you can like, share, and subscribe. This is an interactive show, so we would love for you to be able to give your comments while we have the attorney on the show. And I'm going to bring Attorney Hauron up. How are you, Attorney Hauron?
Hey, Leanne, how you doing?
Yeah, good, doing well. Show because you're very clear, concise about why people need to get a living trust. And people don't realize that if you have classic cars, I know a lot of people have classic cars, you have people that have investments, all of these things are part of a living trust. And so I'm going to let you talk today and let the people know what you have to tell them.
Okay. Leanne, always a pleasure to be here. Thanks so much for having me. It was great to be on your show. And I love, giving information out to the public because it's really important stuff. I guess quickly I should introduce myself. I'm Attorney Hauron Nabhan. I'm an attorney here in Pasadena. I specialize in probate, trust and estates, and conservatorships. Been doing this for about 10 years now. I love this area of law because I get to work with families, I get to work with the elderly, and do a lot of good and really help them plan for the future and deal with what's oftentimes a difficult time in one's life or after a loved one has passed. So it's very gratifying work and really love it. So today we're going to be talking about why you want to avoid probate and why you should have a living trust. If we can, let's see if we can, there we go. There's my slideshow. So I'm going to go through my slideshow, and so a good place to start is we should talk about what happens if you die without an estate plan, if you die without a will or without a trust. Well, I like to say that if you don't have an estate plan, when you die, the state of California will make one for you. And what I mean by that is if you die without a will or without a trust, the state of California will pass on your assets according to California's default intestate succession laws. Basically, your property goes to your closest living relatives, irrespective of how close you were to them during your lifetime, how whether or not you had a relationship with them or not. So if your property is passed on according to California's default laws, your property could be going to your children, even though they haven't visited you since 1998, even though somebody else in your family, really stepped up and took care of you in your old age. The state of California doesn't care. So that's underscores the importance of having an estate plan and putting your wishes down in writing during your lifetime. I like to talk about some examples, from famous people. James Dean. At the height of his career, his short career, because he died unexpectedly in a car accident. James Dean had it all. He had good looks. He was a talented actor. He had a burgeoning movie career. But what he didn't have was a will. And so when he died unexpectedly in his 20s, he had no will, and his entire estate ended up going to his father, which and it's my understanding that James Dean wasn't close at all with his father. His father was largely absent from his life, and was more or less a deadbeat dad. And unfortunately, because Dean didn't have any kind of estate planning in place, everything ended up going to his father, and by all accounts, that certainly wasn't his wishes. Another more recent example is Prince. Prince had a very successful music career, and he largely guarded his intellectual property, and was very successful. Was a very prolific writer, and of course musician in his own right. But when Prince passed away, he didn't have a will in place, and so what ended up happening was, after he died, there was a huge feud among his siblings, his half siblings, and my understanding is a young man making an unsubstantiated claim to be Prince's love child. So this big legal battle went on for years, and I think just recently, I was doing a little bit of research in preparation for the show. I think just recently the litigation was settled, but that we're going on 4 years of court battles over assets, which could have been avoided if Prince had an estate plan in place. And so what we're going to be talking about today is avoiding probate and the importance of having a living trust. What is probate? Probate is the court-supervised administration of somebody's estate after they pass away. It's basically, if you pass away without a living trust, your survivors will have to go to court in order to administer your estate and pass on assets to your survivors. Probate is incredibly costly, and part of the reason for that is because the attorney's fees involved. It's a very difficult process to do on your own. 9 times out of 10, somebody dealing with the probate is going to have to hire an attorney to get some help, because it's a very just esoteric process. Very procedure heavy. The average person will certainly have a hard time navigating it on their own. And so the attorney's fees involved in a probate are set by statute, and they're a percentage of the gross estate value. And so here's a breakdown of what the attorney's fees would be. Just to give you a quick and dirty example. Let's say you have an estate that's worth $1 million, and let's say you have a home worth $750,000. That's based on the median price for a home in California, in Los Angeles actually. And let's say you have bank accounts, retirement accounts, and stocks worth about $250,000. So that adds up to $1 million. Well, on that $1 million estate, the attorney's fees alone would be $23,000. The administrator's fees, the administrator is the person appointed by the court to handle the estate, to administer the estate. The administrator would also get paid $23,000. On top of that, you've got miscellaneous expenses, things like court filing fees, appraisal fees, publication fees. So all that adds up to around $50,000 on $1 million estate. And as we'll talk about later, doing an estate plan during your lifetime costs a fraction of this expense. So, so the point being that probates are incredibly expensive. The other problem is probates are very time consuming. You're looking at least 9 months to 2 years, depending on the complexity of the estate, from start to finish to administer an estate. And obviously, your survivors are likely grieving after losing a loved one. The last thing they want to do is deal with the courts and attorneys and banks and go through 9 months to 2 years of court proceedings. The other problem with probate is the lack of privacy. So if your estate is being administered through the court, all of your personal information becomes part of the court's file, and all that's open to the public. And so all that becomes part of the public record. Your information about your assets, your net worth, your family, all that stuff is basically part of the court file and available to the public. And so I think most people enjoy the privacy and probably want to avoid that if they can. So let's talk about estate planning. Estate planning is the vehicle that we can use to avoid having to go through probate. And so by doing an estate plan, by putting in place certain legal documents, we can avoid having to go through probate after we pass away. It also gives us the opportunity to direct how our property goes after we die. And this sidesteps California's default laws that I talked about earlier. It also gives you the opportunity to plan for your incapacity. So during periods when we become older, and in some cases we're not able to make healthcare decisions on our own, we're not able to make financial decisions on our own, and so having a proper estate plan in place gives us the opportunity to name some trusted individuals to make those decisions. And we'll talk about that a little bit more as we go on. So let's talk about a living trust. A lot of you might be familiar with this term. You might have family members or friends that have living trusts. So let's talk about what it is. A living trust is basically a legal document or an agreement. It's basically an agreement that you make with yourself concerning how you're going to hold property and what's going to happen to the property after you pass away. So a revocable living trust is the preferred estate planning vehicle used here in California. Basically, if let's say you're a married couple and you set up a living trust, are the owners of your property. You're also the managers, and you're also the beneficiaries. So in practical terms, nothing really changes. So if you have a home and you transfer it to your living trust, you still own the home. You still are the beneficiary of that asset. It's just the way that you hold title to the asset is different. You would hold title in trust as trustee. As we keep going back to having a living trust avoids probate. So if you've set up a living trust during your lifetime, after you pass away, your estate does not have to go through probate. If the trust has been properly drafted and funded, your estate would not have to go through probate. One of the beauties of having a living trust is that it maintains your privacy. So because your estate doesn't have to go through a court proceeding, all of your affairs can be handled privately. They can be handled by whoever you designate as the successor trustee, and everything gets handled privately, and the court's not involved in your life. And so, as I mentioned just a moment ago, funding the trust is very important. So I like to use the analogy of a living trust being kind of like a treasure box, a box in which you place your valuable assets. For example, your home, if you have other properties like investment properties, bank accounts, stocks, safe deposit boxes, that sort of thing. All of those assets can be transferred to the trust, and they'll be handled privately through the trust. And so, and it's relatively easy to do. In some cases, an attorney like me can help with transferring the assets, and in other cases, it's something that the clients do. Now, as I mentioned, because if you set up a living trust, you basically get to customize it. You're not beholden to California's default laws. It's your property. you can, for the most part, do whatever you want with it. So one of the great things about setting up a trust is that it's very flexible. So for example, let's say you have a blended family. You have a second marriage, kids from the first marriage, or maybe you're married to somebody that has children from a previous relationship, or you have children from a previous relationship. Well, you can set up your trust so that after one of you passes away, half of the trust becomes irrevocable, and those assets are set aside for your children from the first marriage, or your spouse's children from the first marriage. So that gives you a little bit of control to make sure that your wishes are respected, and that you're providing for all of the people that you want to provide for. Just one example of one way you can set up your estate plan. Another example is you can set up what's called a support trust. So this would be where let's say you have let's say one of your children is not the most financially responsible. You're a little bit concerned about leaving all your hard-earned assets to your child outright, because you're afraid they're going to blow it all at the track, or use it irresponsibly. Well, you can set up a support trust where somebody else, a trustee, is in charge of managing the money, and they have discretion to make distributions to the beneficiary. And so that allows you to exercise a little bit of control to make sure that the funds are used properly and not squandered irresponsibly. Another example is a special needs trust. So some people in a situation where you have children that have special needs, for example, autism or some other kind of developmental disability. This allows you to set up a special type of trust where somebody else manages the assets for your child. And because your child is not receiving the property outright, they would still qualify for public benefits such as SSI or Medi-Cal. It's a great way to provide for a child with special needs and make sure that they're still able to receive public benefits, and a great way to protect them from undue influence or somebody trying to take advantage of them financially. Another option is if you have pets and you're concerned about providing for your pets after you pass away, you can set up a pet trust. You can name a specific trustee. You can name a specific caregiver for your pets, and you can set aside some money to make sure that your pets are comfortable for the rest of their life. And so some other benefits of doing an estate plan. As I mentioned, you wouldn't have to go through probate, and so having a trust allows you to very efficiently transfer assets to your survivors. It alleviates the stress of dealing with banks and lawyers and courts and that sort of thing. When your survivors are likely dealing with the grief of loss. It also allows quick access to funds. If you, on the other hand, if you're going through a probate, it can take as long as 5 months to get somebody appointed as the administrator of the estate. And so having a living trust, basically, as soon as you can obtain a death certificate, your survivors can gain access to the funds in your trust. All right, and we talked about special needs already. Another important point is that having your wishes memorialized in a legal document, I believe, really minimizes the potential for family disputes later on. I think if you have nothing in place, it potentially opens the floodgates for family disputes and possible litigation over who gets what from your estate. But if you have your wishes in writing in a living trust, you can even include what's called a no contest clause, which I won't get into too extensily, but it's a provision in a trust that can be included that basically creates a disincentive for a beneficiary to contest your living trust. So having your wishes down in writing really cuts down on the potential for disputes. Now, I often get asked the question, so if I have a living trust, do I still need a will? The answer is yes. We'll kind of talk about the difference. The main difference is that a will deals with, a will is only effective after you pass away, whereas a trust, it's called a living trust because it's effective immediately. So for example, if you set up a trust and 10 years down the road you start to develop cognitive impairment, dementia, that sort of thing, the living trust is effective. You can name a successor trustee to manage it for you, and so if you're not able to manage your assets on your own, a trusted individual can step in and manage your assets for you. They can pay your bills for you. But with a will, you don't have that same benefit. So it's only effective upon your death. Both documents, a will and a trust, do dispose of property after you pass away. So that's one thing they share in common. But and this is important. If you only have a will, your estate would still have to go through probate. So your wishes are complied with by the court, but your estate would still have to go through probate. On the other hand, if you have a trust, then your estate can be handled privately. A court proceeding is typically not necessary. And so as I said, I am often asked, do I still need a will if I have a trust? The answer is yes. So the will and the trust work together. The will basically acts as kind of a safety net to make sure that any assets that haven't been transferred to your trust are directed to your trust upon your death. So it's really important to have both. Aside from memorializing your wishes, the will serves some other important functions. For example, if you have children that are minors, it gives you the opportunity to nominate guardians to take care of your kids in the event that you and your spouse were to both pass away while your kids are still minors. So that's an important function of a will. It also allows you to express your preferences as far as burial or cremation, or if you want a memorial service, all that can be put down in your will. And it gives you the opportunity to make gifts of tangible personal property, for example, sentimental items or family heirlooms and that sort of thing. Another really important aspect of estate planning is not just passing on property after you pass away, but also coming up for a plan to take care of you later on in life and during any period of incapacity. Real quick, I'll go over some important statistics from Time Magazine regarding aging in America. So Americans are living longer than ever. The number of Americans aged 65 and older is expected to more than double by 2060, increasing from 46 million to 98 million. Life expectancy is also going up. In 1950, the average life expectancy was 68 years old. Now it's gone up to 79. And so while it's great that we're living longer, unfortunately, what we're seeing is that the instances of Alzheimer's disease are also increasing as Americans are living longer and longer. Statistically, 5.7 million Americans have Alzheimer's disease. And it affects about 1 in 10 adults over the age of 65. It's the 6th leading cause of death in the nation, and sadly, there currently is no cure and really no effective treatment. So, these stats really kind of underscore the importance of putting a plan in place to take care of us in our older age, to make sure that there are trusted individuals that'll be there to make financial and medical decisions for us if God forbid one day we're not able to. So one of the ways we can plan for this is through what's called an advanced healthcare directive. This is a legal document that allows you to name a trustworthy person or trustworthy individuals to make healthcare decisions for us if we're not able to. This could be our spouse, this could be our children, or a trusted friend. Another important aspect of the healthcare directive is it allows us to give clear end-of-life instructions. So this would be, in a situation where we have if you have an incurable condition that, within a reasonable degree of medical certainty you're not likely to recover from, this allows you to unequivocally put down what your wishes are. She didn't have a healthcare directive in place, and so that unfortunately led to a really drawn out dispute between her husband and her family. So really important. The other document that's really important in this regard is a power of attorney. And this kind of does the same thing, but for financial matters. So it allows you to appoint somebody as an agent to make financial decisions for you. So this way, a trusted individual can step in, manage your property for you, manage your bank accounts, pay your bills, and you can set it up so that it's only effective once it's medically needed. Now, obviously, you have to carefully choose really responsible and trustworthy people to fulfill these roles. And so, these could be family members, as I mentioned. These could be friends. In some cases, we may not have family members or friends. If that's the case, you can appoint a paid professional, who are known as professional fiduciaries. They're licensed, they're bonded, they do this for a living. So that's always another option. I usually recommend that clients appoint somebody who lives locally, especially for the healthcare directive, because obviously if somebody has to step in a pinch to make decisions for you, you want somebody that's going to be easily available. It's really important to have these documents in place, the power of attorney and healthcare directive, because if you don't have these types of legal documents in place, what could potentially happen is somebody will have to be appointed by the court to make these decisions for you. And that would necessitate what's called a conservatorship proceeding. Again, anytime the court's involved in your life, it's incredibly expensive. It's very time consuming. It kind of compromises your privacy because, all of your information is part of the public record. Just as importantly, with conservatorships, there's always the potential for family disputes. One child wants to be appointed as conservator. The other child is opposed to their appointment, and they want to be the conservator. I see it all the time. They're fights. It just opens Pandora's box for fights. So having documents in place, really obviates the need for a conservatorship and minimizes the potential of having your family members fight over who gets appointed. And importantly, also, it having for example, having a power of attorney in place really minimizes the potential for financial elder abuse. Unfortunately, as we're living longer and longer and to an older age, we are seeing a lot more financial elder abuse going on, and it's really sad. And so having a power of attorney in place, naming a trusted individual as an agent to step in and manage your finances for you, really cuts down on the potential for financial elder abuse, or if your loved ones discover that there is some kind of abuse going on, they can immediately step in, take over as agent under your power of attorney, and they can really put an end to the abuse. So I think that's my time. That's if there are any questions, or Leanne, if you have any questions, I'm happy to hang out and answer those. Otherwise, I'd like to open it up to anybody that free 1-hour consultation. You can reach me by email or by telephone. happy to talk to you and happy to give you a consultation and answer any questions you might have.
Okay, that's great. And we do have Hauron's information scrolling on the bottom of the screen. So if you are interested in getting that free consultation from him, the information is listed below. Thanks, Hauron. That was great information. You shared a lot of information. I think a lot of times people tell me, well, I have a will, or my parents have a will.
Yeah.
And I'm not a lawyer, but I do know that wills can be contested. So
they can. Yeah, absolutely.
Can you explain that a little bit?
Yeah. So, there's always the potential for somebody contesting a will or a trust. It's always possible, and I think if you have a situation where you're thinking you might want to exclude certain people from your estate, or you might want to leave a little more to somebody else, I think it's really important to do your estate planning with an attorney, especially somebody that has some knowledge of litigation in this area, because we know what to avoid, and we know how to draft the documents so that it really cuts down on the potential for a contest later on. Some people, when I'm confronted with a situation like that, where somebody says, well, I'm thinking of disinheriting my son. He hasn't been involved in my life. We don't have the best relationship. On the other hand, my daughter is a saint and she's been taking care of me, for the last 10 years. When somebody like that walks into my office, I try to do everything I can to make sure that I draft, well-drafted documents that won't be contested. In some cases, I ask the client to go out and get a letter from their doctor stating that the doctor has examined them, has talked to them, and in their medical opinion, that person has capacity to make a will or make a trust. In some cases, I might ask the client to memorialize in a letter, why they're deciding to do their estate plan this way. Some attorneys in some cases might record the client as well. They might take a video of the client talking about their testamentary wishes. So, there's a lot of creative ways that we can, we can try to minimize the potential for a trust contest. It's always possible, and a lot of times people are, they're driven by their emotions. And if mom excluded me from her living trust, it means she didn't love me, or she loved my sister more than she loved me, right? So. But the point being, we do everything as a planner, I do everything that I can to try to minimize the likelihood of a contest later on.
Yeah, well, that's good. And the other thing that I'm aware of is that you want to get a living trust because you do not want the state to get in your business. That's the state. Yeah. Okay, and it goes public. Okay.
Right.
Having a living trust, it's all private. It's all within whatever you and your attorney discuss.
Right.
And you have hard-earned assets that you've worked hard for all your life.
Yeah.
And as I stated in my previous shows, as a real estate broker, I, get called to sell a parent's home. And when I run title, I find out that they're not on title. And I explained to them that, you have to suggest Attorney Hauron, have them call you.
Yeah.
And they're like, how much? And I said, you have to talk to him about it, but it has to go that way. And there are other siblings. And, I gave my view on it last time. I mean, I've seen fights, very bad arguments.
Yeah.
Sometimes around, if they're in the probate process, sometimes it happens before the probate process, but say they've gone through the probate process, the buyers are there, trying to do their inspection, and all of this is happening in front of them. This should not happen. This should not happen. And it only takes a phone call for you to call Attorney Hauron Nabhan, and his information is scrolling below. Protect your assets, everybody. If you need a free consultation, he'll be more than happy to assist you. And we want everybody. That's why I do this show. I usually do live seminars, but because of COVID, we're not able to do that. But we want to get this information out. It is, and I can ask you this, it's less costly to go through a living trust than for your children or whomever is going to take over your estate after. It's a lot more expensive.
Absolutely, yeah. It's literally a fraction of the cost of having to go through a probate. Again, the typical example I gave of $1 million estate, which here in California, it's if you pass away owning a home and a couple $100,000 in bank accounts, it's easily $1 million. And so the fees associated with that, you're looking at about $50,000, and it's and not to mention the time and just all the negatives associated with probate.
That's right.
So
that's right.
It's really, if you look at it that way, it is an investment, and it is worth the money, in my opinion.
Yeah.
Avoid all the headache and all the expense later on.
That's right. It is, and it's a peace of mind. It's a peace of mind, because, like you said, if and I always think about. Most of them, I knew the parents, and I think about them. They've held that home for 50 years or more. And I know that this is not something that they expected. But, a lot of times you tell people that and they'll say, oh, the children will take care of it. They'll work it out. No, they will not.
Yeah.
It doesn't always work that way.
Yeah. I see so many cases of, people, and I get it. It's not the easiest thing to think about. And it's something that people do put off and put off and put off, and they just kind of mistakenly assume that the kids will just take care of it.
Yeah.
The property will get passed to them somehow, and it won't be a big deal. But it's when you don't do this planning, it just opens the box to all kinds of issues later on.
Well, Hauron, we got a couple of comments over here. Again, thanks to everyone for chiming in. See, we have a comment from Lenore Moore, and she says, great information. Great. Thank you. And we also have Lucy. It's a treasure chest. It is. It really is.
Yeah.
People need to have this information. And she also said, can you touch on bank accounts that are tied to trust? I know when a property in a trust is sold, the money has to be deposited into the trust. Can you talk about that a little bit?
Yeah, I think I understand Lucy's question. When you're acting as trustee, so let's say both of the people that created the trust, the settlors, have passed away, and now a successor is taking over, and so that could be one of the couple's children. When that person is managing the trust, obviously they don't want to commingle any of their own personal assets with the trust assets. So typically what has to happen is that person has to open up an entirely separate bank account for the trust. They would get a separate EIN number from the IRS for tax purposes. They would set up a separate account, and if there is property that gets sold, for example, like let's say there's a home that gets sold, the net proceeds from the sale would have to go into that separate account. And the other thing to mention is that so if a successor trustee is managing the trust after, let's say after the creators pass away, they are responsible for accounting to the beneficiaries of the trust. So for example, if you put one of your children in charge as trustee, and you have 3 children, the trustee child, the one who's in charge, does have to account to his, his or her brother and sister. And so that underscores the importance of keeping separate accounts, not commingling funds, keeping very good records of the expenses you're paying from the trust, the income that's going into the trust. All that's really important. And if depending on the complexity of the trust, you may have to have you may have to work with other professionals like an accountant or an attorney to advise you as far as how to manage that. I think Lucy, let's see, is Lucy giving us a follow-up question? Oh, okay, it's the same question. So I think hopefully that answers Lucy's question. But great question. That's really important. Everything has to be kept separate. Whoever's managing as trustee has to account to the other beneficiaries. Everything has to be obviously according to the law and for the benefit of the beneficiaries.
Okay. All right. Well, let's see if we have any more questions here. It doesn't look like it. And she does say thank you. We do have another question here. Let's see. Can you read that, Hauron, there? It says, over the last 5 to 10 years in LA County, what has been your experience in finding an increase in the number of litigation cases against the living trust? Are you seeing a rise in the number of cases filed in fully legitimate? I guess that's what he's saying.
Yeah. That's a good question. Thank you. Thank you, Lindsay. So like I said, in most cases, as a drafter, I try to take, every kind of precaution I can to avoid any kind of a contest later on. If I have somebody come into my office and I'm, a little iffy about their capacity, if I don't think that, they have the capacity to do an estate plan, I will politely decline to do it. But I can talk a little bit about trust litigation. So,
okay. So
there, to answer Lonzi's question, you do see some contests come up. It's inevitable sometimes, and as I was alluding to earlier, people are fueled by their emotions, and if mom cut me out of her estate plan, well, that means that she didn't love me. Mom might have had a legitimate reason for doing that, but people are definitely fueled by their emotions, and that kind of that fuels this type of litigation. But there are a couple of different legal bases on which somebody can contest an estate plan. So one is lack of testamentary capacity. So that's if the person making the will or making the trust didn't have the mental capacity at the time that the document was signed to do so. And so there are all kinds of tests for this that are memorialized in the probate code. Basically, what the court's going to be looking at is, did this person have the capacity to understand who their family members were? Did they have the capacity to know what assets they owned? And, did they have the capacity to understand the ramifications of how they're distributing their property per their trust and their estate plan? And so, trust litigation is unique in the way that the person most, the best witness to, in the case is already deceased. And so, basically the way you would prove a trust litigation case is through medical records, through testimony from expert testimony, through, the individual's treating physician, testimony from percipient witnesses. So that would be, other family members that were around that knew that the decedent knew what their wishes were. Sometimes caregivers can testify as to what somebody's capacity was like, but I would say that's the most common ground to attack an estate plan on is lack of testamentary capacity. Another one is undue influence, and so undue influence is basically a claim that somebody else came along and through very excessive persuasion convinced the decedent to make their estate plan a certain way. This could be if, for example, let's say a caregiver came along and kind of cozied up to the decedent at a time when they were very susceptible, because they were reliant on that caregiver for their care needs. And when I say caregiver, this could be a family member. This could be a family member that was living with the elderly person. And so to prove a claim of undue influence, you have to show that the elderly person was vulnerable, they were susceptible to the influence of somebody else, and that they were reliant on them for their care. And so you have to show that the excessive persuasion was so excessive that it basically overcame the free will of the elderly person. And so it's a difficult claim to prove, because it's just kind of a difficult claim to prove, but it is something that it is one ground that you can contest an estate plan based on. Another basis for contesting a estate plan would be like fraud or mistake. That would be if somebody, flat out forged the documents, flat out forged the will or the deed transferring the property to somebody else. Those are not as common. I don't see too many of those coming up, but every once in a while they do pop up. Sometimes mistake is another basis for a contest. I actually have a case going on right now where we're alleging that the decedent, we're contesting the estate plan based on mistake, because the decedent didn't prepare his estate plan with an attorney. He went to a paralegal, whose knowledge of the law was pretty limited, and so that's one of the grounds that we're contesting the estate plan on. So moral of the story is, it's really important to, if you are concerned about somebody contesting your estate plan later on, I think it's really important to do these documents with an experienced attorney that, preferably somebody that also does trust litigation, so they kind of know what to watch out for, and they can advise you properly and make sure that precautions are taken so that your documents aren't contested later on.
Wow, great information. Yeah. So, and he says, excellent legal analysis, basic explanation. Thank you, Lonzie. And I want to thank everybody for joining in on Kitchen Talk. This is, like I said, this is something dear to my heart because I'm in real estate, really bad situations when you have to get, the family has to get a probate.
Yeah.
And when I work with families that have living trust, some of it is peaceful. You still have some family members that don't agree, but even their attorney will say, it's nothing you can do. You have a living trust, or a living trust was established. I'm sorry. Yeah. So it has to go based on that person's wishes. So it can be a peaceful transaction, and it can't be disturbed, and that's the way people should really want it. Yeah. So we want to thank everybody for joining Kitchen Talk today. Again, we have Attorney Nabhan here on the show live. If you have any questions about probate, wills, living trust, how much, is it based on, my assets, or whatever questions you have, please feel free to give him a call. His phone number is listed on the screen. You can also contact me via Facebook or my website. Attorney has his own Facebook page as well. Reach
Mhm.
out to him. I do want to thank you, Attorney Hauron, for coming on the show again. I love the way you explain things to people. I love the Prince example. I mean, that is a prime example. This guy had millions
Yeah.
and he didn't have a living trust. And remember, he had family members that saying that they were related. One was in jail. They had to go and do a blood test, and
Right.
nobody should want that.
It,
Nobody should want that.
it's really surprising, and
Yeah,
he was a great businessman. I mean, he really guarded his the rights to his music, and very savvy, but just so surprising that he didn't have an estate
yeah,
plan. Yeah.
yeah. So that's why we're telling everybody out there: get a living trust, please, please, please. And one would ask me, why am I so passionate about this? Well, because I'm in real estate and I do this all the time. I work with standard sales. I work with probates and also living trust. I prefer to work with the living trust transaction.
Yeah.
And like I said, I don't get any benefits from this other than sharing this information. However, I do ask that if you do get a living trust, that you will allow impressive properties to assist your family in the trust at that time. So I am providing this. I will do this. I've been in business 24 years. I will continue to share this word. And I really think it's really important. Attorney, thank you for coming on the show. And we're going to continue to do this show because, hey, this is what's going on. We got to share it, right?
Absolutely.
Okay. So
Thank you so much.
thank you. You have a wonderful day, and we'll talk soon.
Thank you.
All right. Thank you. All right, everybody. Thank you for joining Kitchen Talk today. Lucy is with Old Republic Title. I work with her in my real estate business, and we wanted to share some information about this proposition in the California ballots coming up for November the 3rd. Also, if you are a homeowner out there and you want to check your title, feel free to reach out to me. That information is free. And if you have any real estate needs at all, please feel free to reach out to me. I am a real estate broker in California. We handle residential and commercial real estate. And I am also a realtor in Las Vegas, Nevada. And I always stress the new home of the Las Vegas Raiders. So I'm going to leave you with a video. Hopefully, we'll have enough time to show that during the show. And it will tell you a little bit about Proposition 19. So thank you for joining the show. Wear your mask and stay safe, everybody.
There are two main parts to Prop 19, a tax increase and a sweetener. The tax hike is on some people who inherit property from their families, and the sweetener is a way to help seniors, the disabled, and victims of wildfires and disasters. This is the second question that goes back to that old deal from 1978. That's when California enacted Prop 13, a law to keep property taxes down. Even if your home value goes way up, your property tax is only allowed to go up 2% a year. The older you get, the sweeter this deal becomes, but it has a side effect. It keeps seniors from wanting to move, worried that they'll pay much higher taxes if they go buy a new house. To help people over 55, also disaster survivors and the disabled, the law currently allows them to take this lower tax base and move it to a new home. But you only get to use this special rule if the new home is worth less than the old one. You can only use it once in a lifetime, and only within the same county or a select group of counties that allow transfers. Prop 19 would change all that. You could move your lower tax base to a pricier home and only pay the difference. You could move this way up to 3 times, and you could move to a new home anywhere in the state without losing your lower tax base. That's the sweetener. Now the tax hike, which is all about inheritance. When you die, if you leave your property to your kids and grandkids, they get to keep your lower tax base. If you inherit the house, this is a sweetheart deal. You get to pay taxes based on the last generation's property value. Prop 19 would raise property taxes by ending that inherited tax break in many cases. It's aimed at wealthy families who own big properties. Prop 19 still allows this tax break if you inherit your parents' house and decide to live in it. It also exempts farms. But if your mom or dad left you a bunch of rental properties or a strip mall, your property taxes on those would go up under Prop 19. Over time, the analysts figure Prop 19 would increase property taxes by a few $100 million per year. Most of those new taxes would be dedicated to fire protection, but some would also go to local governments. A yes vote allows more flexible moves and increases the tax on inherited properties. A no vote keeps the law the way it is.